let's assume sometimes, as we make decisions, sometimes bad decisions, and we go through and we decide to go through with a court martial. And we didn't hire an attorney, right? And we're convicted. Now, is it advisable? Is it too late to hire an attorney now? Can we hire an attorney for sentencing, or can we hire them to help us with what seems to be too late?
In the military, it's important to remember that at least for now, this all could change, but at least for now, sentencing and the trial on the merits happens one after the other. So if you're convicted at a court martial, unlike state court or federal court, let's say you're convicted on the merits, you're gonna be held over, you're gonna get a sentencing date set, they're gonna do a PSI or a preliminary sentencing investigation. And all of that's going to happen over a period of months before your sentencing hearing. Well, not in the military. We're expedient, if nothing else. I mean, you can get a guilty verdict literally at 1700 on a Thursday, and your life just got destroyed. And let's say it's sex assault. Now you know you're a convicted sex offender. You know you're going to prison, just a matter of how long. And your life just got freaking ruined with one verdict. You don't really have even time to process that. The military judge will often get back on the bench, ask the defense how much time we need, and that's 10 minutes or 15 minutes usually. We'll go out, decompress, and kind of debrief our client, and we go right back in for sentencing, literally the same day, oftentimes within 15 minutes. If it's at the end of the day, sometimes we'll break and do it the following day, but the most you're going to get is an overnight. And so you cannot hire another attorney to do your sentencing if your lawyer screwed up at trial. And so the problem with that, or the interesting thing, is you have to prepare your sentencing case as well. So in a case that we're preparing to defend, we also have to put a team on to do the sentencing piece, to do all the E&M, the extenuation and mitigation, learn about our client's life, their backstory, what was mitigating about these set of facts, what are the extenuating circumstances, and have all of that case ready to go. So when you hire us, you're not only hiring us to do the merits portion of the trial to get you found not guilty, but if you're found guilty of anything, and let's say you have a sexual assault case and you beat all the sexual assault charges, but you get hit with a fraternization, or you get hit with violating curfew or some ash and trash charge which they tack on, we're going to sentencing, and we need to have all of that lined up. So unlike a lot of cases, we're doing both the sentencing and we're doing the merits. And the best position we're going to have is if we get a full acquittal and we don't need to go to sentencing, but we need to have that prepared. And so you really can't hire an attorney to do just the sentencing. And if your attorney sucked on the merits and they did a crap job for you, they're probably going to do a pretty lousy job in sentencing. So what you're going to have is a case where maybe if you had a very good attorney, you would have been found not guilty. Now because your attorney was garbage, you get convicted. They're probably going to be garbage on sentencing. Now you're going to get a higher sentence. And so these soldiers and these Marines and they just get destroyed if they don't have competent counsel, because the same screw ups that happen on the merits portion of the trial happen on sentencing. And that's what happens when you see these kids doing 20, 25 years in prison for something where the same exact case, you may have a very highly skilled civilian attorney tried and they get found not guilty. Or if they get found guilty, you can get very low sentences. And let me just add one more piece on this. We don't win every case. I wish I could. Any lawyer that says they won every case is just full of crap. And so, we had a case go to trial last year where a client was convicted. There was DNA evidence, there was a confession, there was a lot of bad evidence, but he received 18 months confinement. And that was for essentially a forcible rape case that he was accused of, where the government had offered a deal of 10 years. And so had he took a guilty plea, he'd be doing 10 years in prison. He ended up getting 18 months. And so by actually trying the case, now there's a lot of appellate issues as well, by actually trying the case, he received a lower sentence than if he would have pled guilty. And so it's something to think about as well.